Welcome to this, the 25th Planning Podcast. I'm Richard Kimblin, and today the topic for the Planning Podcast is the long, indeed the seemingly never-ending examination. Let's have a look at those, what draws them out, and how some of the reform agenda might have an impact. We are flattered to be joined today by Jerry Youle, Inspector and Professional Lead for Local Plans at the Planning Inspectorate, Satnam Choongh, Planning and Environmental Barrister at No5 Chambers, Burden and David Murray-Cox, each Planning Directors at Turley. Good morning all.
Good morning, Richard.
Hi.
Morning.
Like many listening, I might contribute to 3 or 4 examinations in the course of a year, and so I focus on my own experience. But it would be great to see the bigger picture and to learn about the rate and number of examinations which are undertaken. And I wondered, Jerry, whether or not you're able to help with some of the background numbers so we know what the bigger picture is.
Yeah, and I think we're kind of thinking here, aren't we? The topic is why do these things take so long? So what is actually going on? Well, yeah, I looked at the stats on this recently. Most examinations do go through in a year to year and a half, which does sound like quite a long time anyway, doesn't it? So that's for the more straightforward ones, where they go through the normal process of hearings, main mods, final report, maybe a couple of stages of hearings, some twists and turns along the way. That is quite a long time, given we appoint an inspector straight away. It's not, these things are not hanging around in Temple Key waiting for someone to do some work on them for a while, but they are big things, obviously. But the more problematic side is that we have a number of plans that have been in examination for quite a lot longer than that. So we have 65 plans in examination at the moment, and of those, 16 are transitional plans being examined against the 2012 National Planning Policy Framework. So that's counting North Essex as one plan, whereas in fact it's 3 plans, and part of each of those 3 plans have already been adopted. So there's a nice simple example of our planning system at the moment. So 16 submitted over 2 years ago now. The oldest is going to celebrate its 4th birthday this week, and I won't be sending it a cake if that was possible. So I won't be, because that's not good. We also have 4 plans that are being considered against the more recent current NPPF, which have now also reached the 2-year point. And that means that you'll probably be picking up on this. The local housing need calculation needs to be redone because it's only good for 2 years once you get an examination. So that means we have about a third of our plans have been with us for over 2 years. So that's obviously not good from anyone's point of view. From our point of view, we shouldn't really have to appoint an inspector to do a piece of work in the hope that 4 years later, they'll still be working for us. They won't have left to go and work for Tim and David or retired. So that's not good. And of course, the longer these things go on, the kind of worse it gets, because events happen, national policy changes, new housing projections come out, council staff leave, new heads of planning take over, political parties take, everything changes. And, the delays tend to stack up. 4 years, how on earth does anyone keep up with what's going on in an examination that lasts almost as long as the plan's time period? Most do get through faster than a year. Most get through in a year to year and a half, but there is a sizable romp that don't, and they are a problem.
Well, that's a terrific overview and very frank. And it will come back to some of those broad features and how long some plans take when we have a little look at the reform agenda a bit later. But it might be worth turning to Tim and David on the topic of some of those examples that Jerry's alluded to. Of course, Jerry's not going to be commenting at all on the particular circumstances in any of those examinations. That wouldn't be appropriate. But you can. You're free to say what you like, Tim and David, about, for example, North Essex, other longer examinations you've been involved with.
I think one thing we're noticing, Richard, is that local planning examinations do go on longer, largely because I think the Planning Inspectorate are trying to encourage councils to get their house in order, to deal with main mods, to try and find a way through finding plans sound that maybe 3 or 4 years ago, I think the inspectors would give a council a year basically, post the main hearing sessions to come back and reconvene. And what we're seeing is that no longer seems to apply. So we have some cases, for example, at Tandridge, because of fairly fundamental issues with the Highways Agency and some infrastructure provision. That plan has carried on extending, and I think that is one of the plans that's probably a good 3 years old now at examination. And obviously that doesn't account for the number of years it takes to get to that stage in the first place, hence why I think the average age of plan production now is something like 7 years, I think I've seen quoted recently. So it's that back end and the front end, and I think inspectors are doing their best with what's in front of them to try and make plans sound, notwithstanding maybe the evidence doesn't support that. I think it puts everyone in quite a difficult position.
Mm. Mm.
Yeah, just to throw my thoughts into the hat, Richard, in my experience, which admittedly isn't quite as lengthy as Tim's, the issues really fall into several categories. There's plans where there's been a significant degree of political meddling in the plan. Then there's plans where the evidence simply isn't sufficient at the time of submission. And then there's a category where probably both of those apply. And there's been some reference to the North Essex plan so already in this discussion. And that was clearly a set of plans where, for want of a better phrase, the authorities collectively shot for the stars. But what the evidence didn't do was give the inspector any of the evidence required to get there.
So what you've done is you've picked out, on the one hand, politics, and on the other hand, evidential support.
Yeah, exactly. Sorry, Richard.
And so, no, not at all. So it seems that those are two key areas which you identify as leading to a longer examination.
Yeah, one of the examples that I wanted just to refer to in passing, and it's a little older than would be preferable now, but is that of West Berkshire, where I had some involvement with their core strategy, which I think was adopted in 2012, if memory serves me right. And Tim and I were reflecting yesterday on the various stages that plan had to go through. And that had to deal with the Homes for the Future consultation, the draft framework, the published framework. It had to deal with Eric Pickle's letter about the revocation of the South East Plan. It then had to deal with the legal challenges that followed that, and it had to deal with the actual revocation of the South East Plan. And at each stage, the inspector gave all parties the opportunity to comment on the consequence. And the output, essentially, was everybody at the local authority seemed to take the view that a bad plan was better than no plan at all. And we sit here now, 9 years after the event, and the council's currently at a public inquiry regarding one of its key allocations with 13 reasons for refusal. In that case, has a bad plan delivered anything at all? And the answer probably is not really.
So we've got a trio. We've got politics, evidence, and events, and then pushing on, nevertheless, to adoption can produce the opposite of good forward planning. Satnam.
I was fascinated by the stats that Jerry gave us and how they fed into the reform agenda. So when Jerry said that the vast majority of plans get through within a year to a year and a half, I said, well, that's only 12 to 18 months. How does that relate to the 7 years that I've been looking at in the government publications? I mean, leaving aside the rump of cases that you refer to, Jerry, which take longer, if the vast majority are going through within 12 to 18 months once they get to the inspectorate, it seems to me that the vast majority of the time that's been taken is being taken by local authorities themselves before they actually submit the plan. And I wonder whether any empirical research has been done to have a look at those plans that take several years to even be submitted to the inspectorate and why that is. And then some further empirical research to look at the rump of cases that you say, even when they get to the inspectorate, they take longer. So you've given examples of those which have been submitted 2 years ago and those which have been submitted 4 years ago. It would be helpful before the government embarks upon any reform to just do a study of those which take longer once they've been submitted to the inspectorate to try and identify whether they have any shared characteristics. What is it about that small rump of cases which means that they take longer. And then you have sort of evidence-based reform rather than just saying, well, plans are taking up to 7 years, let's carry out some reforms. If the reforms are going to be targeted at that stage of the process which the inspectorate is concerned with, it's not actually dealing with that part of the process which seems to be taking the longest amount of time, which is the period before the plan is even submitted.
I think that's a very valid point, Satnam, and one of the things we always find difficulty with is going back to the evidence base and finding that paper trail, because there is always a degree of politics, quite understandably, that comes into site selection process and the approach to the formulation of the local plan. But we see multiple Reg 18 consultations, and then often multiple Reg 19 consultations, then further call for sites, and the degree of procrastination there is very frustrating. And we, as promoters of site, we have to get involved in each of those stages. And I think one thing that would be good to see out of any proposed changes to local plan process is some clarity on the evidence base that is required. There's always discussions around the essay at CIPs. There's always quite heated debates about the Greenbelt assessments, because largely by their very nature, sites that are in the Greenbelt will fulfil the Greenbelt purposes because they have done for many years beforehand. Should Greenbelt assessment be amended to incorporate essay in that process to ensure that the site selection process is a bit more rounded rather than simply on the basis of Greenbelt? These sort of issues come up in all sorts of examinations, and just the lack of evidence. I touched on Tanbridge earlier. Their issue was with the lack of highways evidence. We had a similar thing a couple of years ago with Runnymede, where the first day of the examination, the inspector was somewhat aghast that there wasn't an agreed position with Highways England. Do we need a framework, I suppose, in place that says your local plan evidence should deal with these issues? You should have this support to underpin what you're saying is now a sound plan? Because the amount of examination time that is wasted on things that frankly should have been really put to bed before what should be considered a sound plan is submitted, it just doesn't exist, and it's frustrating for all that engage in the process. I think I always feel the most for the general public. It's the evidence base is impenetrable at times, even for us as professionals. So it's all very well talking about digital revolution of planning, but the documents have got to be there in a form that's accessible in the first place. And I think that's something I hope we'll see some streamlining of the expectations of local authorities moving forward.
Let's see what Jerry has to say, if he wants to respond to any.
Yeah, I was going to say I need to be very careful about what I say about planning reform, because of course that's government and MHCLG, not us at the inspectorate, who are merely an arm's length executive agency. I've not seen any empirical research of the sort that was mentioned, but I think anecdotally we've probably kind of nailed it between us. Really, we know the problems for delay in those authorities is, and the examination is just the end of the process. The really hard work is the local authorities preparing these things, because they're huge things to do. So it's the politics; they're very difficult to do. They have to do things that can be electorally unpopular. The evidence, as you say, pretty difficult to collect the right evidence to justify a plan. And I think there's probably an issue with local authority resources. It's not uncommon for inspectors to report back to me there are not many people dealing with planning policy, even where the plan's going through examination. So I think those three things probably what caused the delay. Yeah, going back to the earlier comment, why do these things go on so long? Well, it's the structure of the Act, really, because Section 20 says inspectors must recommend modifications to make a plan sound if a local authority requests that. Yeah, going back a few years, there were a couple of high-profile cases, weren't there, where the inspector did pull the plug on the examination, and that was quite controversial. But you go back to the Act, that's what the Act says, and that's what leads to the perpetual examination. You examine the plan until it can be found sound, however long it takes, even if really the local authority then has to do during the examination is go back and do some more plan preparation, which of course isn't really what an examination ought to be about.
That really is interesting, isn't it, Jerry, in terms of the structure of the Act? I mean, I suppose I never really thought about it in that way before, but I suppose thinking about that logically, it's possible under the structure of the Act for a local planning authority to submit a plan which is terrible and which it may know is not the best plan, and then just really throw itself not at the mercy of the inspector, but almost well, can you please do our job for us? Can you please tell us what modifications we need to make this plan sound? When you think about it in those terms, it does seem to be a system which is not great, because the role of the inspector should be to examine the plan, not make the plan for the authority.
Yeah.
Well, it makes it more difficult.
Yeah.
Picking up on that point, Satnam, Tim and I were just talking about the Windsor of Maidenhead local plan, and that one, I think from memory, was submitted in the early part of 2018. And that's a plan where I have to be careful what we say here, because we represent people with proposed allocations, of course. That's a plan where the inspector has done a huge amount of work to tell the authority what additional material they require. And that's included things like flood risk assessment work for the proposed allocations. And there's been a huge number of changes to that plan, when in reality, had the evidence supported the plan in the first place, well, we might have an adopted local plan in Windsor and Maidenhead now for the first time in 2 decades?
I think there's a follow-on point on that as well. I think there are some local authorities that, dare I say, are planning to fail. The number of repeated examinations we attend. There's obviously the folklore of York, their 1954 plan, St Albans 1994. These are, well, older than me, dare I say, so at least one of them. And the reality.
Surely not.
The reality is that it's not a vote winner. So we get into a position here of, well, how can government insist on plans being put in place? And we heard this at the time of the 2012 NPPF, the 2019 one. What is actually going to happen to make things move forward? And we had the Secretary of State's letter in 2017. And there were 15 local authorities, if everyone recalls, that were put on the naughty step. By my estimations, I think probably half of them still don't have an up-to-date adopted local plan. We've got a few that are examination at the moment, but those that still haven't even submitted a local plan don't appear to be subject to any sort of repercussions, and that can't be good. And we need, moving forward in planning reform, to be able to change that. So plan making seen as a positive, and I don't think at the moment it is.
Can I just see where we've got to? Because we've got a long way in, not very long there. I think where we've got to is identifying a problem with evidence which an inspector can reasonably expect to be present if a plan has been submitted by an authority that does think that it is sound, which is what they're required to do. Evidence. You've only got two ways through that, really. You can either say, well, once you put your evidence in with the submission plan, that's it. The result there is that more plans will be found to be unsound and then go back to the starting point. Or you allow the plans to run on longer. Are you not left then with a choice between rock and a hard place? You don't want to be finding plans unsound, because we want there to be a plan-led system. But on the other hand, for perhaps a relatively small number of authorities, we're allowing a fairly slack approach to take place. And isn't it a choice between those two options?
Just one comment around that. I mean, I genuinely think our inspectors do their best to move these examinations along and get them to the end point, because why would anyone want to be working on one plan for 2, 3 or 4 years? They might like to go somewhere else and do a different one. So they do work hard at it. For some of these plans, some of the ones you talked about, inspectors have said there are two options here. One option is under the Act, you can ask for main modifications to be recommended, but that is going to take a long time. And of course, there is no guarantee that what the council come up with will be okay the second time around. It could be an examination for a very long time. The other option is withdraw the plan, go and sort it all out. When you have, then resubmit it. And some local authorities, in fairness, have done that, withdrawn their plans, but most tend to want to carry on because it's not a palatable option to take your plan away, is it?
I would agree with you entirely on that, Jerry. I feel for planning inspectors, because I think they do an absolutely fantastic job trying to deal with so many competing interests in it. I think a good example of that at the moment is at Aylesbury, where Mr. Clark is examining their plan. And that's Aylesbury's third attempt now to get a new local plan in place. And I've had the privilege of appearing at each of those EIPs in over a decade. And he is doing an amazing job of trying to get that plan over the line. So much so, I think a couple of weeks ago when we had the latest sets of hearings, that he was referring back to view he gave back in the 2018 hearings. So I think that's probably one that's on your 3 or 4 year timetable.
Pretty sharp memory, don't you, to deal with?
I couldn't remember what he said, but I'm pleased he could. So,
well, I actually had a look at their website this morning, and there is in fact a sort of chronology of what's gone on, fairly shortly stated. And if you look at one of the 2018 entries, it says this: "This is an incredibly complex plan which will affect the Vale for generations to come, and getting it right is our priority." And that's kind of what's being said, isn't it? We're just going to keep going until we get it right. We just didn't expect it to take from 2018 till mid 2021.
From what everyone has said, isn't it the case that what's needed is a greater focus on what local authorities are doing rather than what's happening in the examination? Because once you've got to the examination stage, it can be too late to fix things, or it can become a very lengthy process to fix things. So it seems to me, from what everyone's saying, that the real resources and the training and the guidance has to be focused on local planning authorities. They have to be told or guided, this is what you need to do. This is the evidence that is needed to be submitted with your plan. And either they need to be given, well, they certainly need to be given resources. I don't think anybody would disagree that more resources are required. I mean, I read a statistic saying that, I don't know, I was thinking the RTPI was saying that funding for planning authorities has been cut by something like 55% over the last 5 to 8 years. I mean, those are huge cuts. So we're talking about reform, we're talking about getting plans to be quicker, etc., etc. There seems to be a lack of any kind of research, focused research, asking what is it that local planning authorities are getting wrong, why are they getting it wrong, what training is required, what resources are required. There doesn't seem to be, maybe I've missed it, maybe it's all out there, I just haven't read it, but I've not seen anything like that.
Richard, there are a couple of points that I thought I'd just pick up. It might be that Jerry can assist with the first of these. From our perspective as consultants, when we're putting planning applications together, we know firstly what the material is that we are required to provide, and we also know what the tests are that the local authority or a planning inspector will apply in the decision-making process. And having participated in a number of examinations, I'm not entirely convinced that local authorities have the same understanding when it comes to a local plan. And the example that strikes me is another one from North Essex as well.
I remember it well.
We spent about a couple of hours early last year debating whether or not there should have been a heritage assessment required to support strategic allocations to make the necessary decisions. The other point that I just wanted to mention was the length and complexity of local plans. I've just submitted representations for an authority in North Kent. Their local plan consultation on their Reg 19 closed last Friday, and the draft local plan is something like 350 pages long. That's both allocations and development management policies, many of which simply require that you comply with other policies in the plan. And the question I have, is that giving the inspector, let alone the public and other participants, simply too much to grapple with? Do you need 350 pages to say which sites are going to deliver, how much development there will be, and what standards it should comply with?
I think as well, Dave, there was an interesting point in the planning white paper about trying to standardise some of these generic development management policies, which I think would be really helpful, because one drainage-related policy in one local plan is going to be very similar to another authority's one, I would assume, or at least I'd hope. Not always the case, but actually if they're standardised at a national level, there is no need for local plans to deal with those then. And that would be a really, I think, a beneficial way of streamlining the system, save examination time, and just give clarity to all involved in the system.
Okay, so two thoughts on that. Evidence. People do ask us, they ask me, what's the Planning Inspectorate's view on the evidence that's required for a local plan examination? And of course, we don't have a view on that stuff because we don't invent national policy. So the answer is the evidence you're required to produce for a local plan is whatever national policy and guidance tells you. So that's the answer to that one. But it will be interesting to see if planning reform, but I think it is an issue, we've clearly seen that in some of the examinations you've talked about. So it'd be interesting to see if planning reform does something about that, because you could envisage having a much tighter list of evidential requirements that a local authority has to produce for a particular type of plan. And you could also, this point about it takes a long time to prepare them and then they come unstuck in the examination, which is right at the end. And maybe some plans have been submitted without the right evidence. And we know that, you could have a gateway test or gateway tests even. You can't get into examination until certain criteria or tests have been met. One of those could be, have you done the following evidence? That's easy if it's kind of factual test. It becomes a bit more difficult if it's kind of quality test. But, we could probably think of something, couldn't we, as a planning world on that. So it'd be interesting if planning reform comes up with that. And it is a proposal, isn't it? National development management policies. I'm a little bit unsure about how much that actually adds to the time of examinations, because development management policies are usually fairly easy to straighten out. It seems to me the big controversial stuff is housing requirement, housing supply, sites, isn't it? It's that stuff that really causes the controversy.
So the length of time is the origin of that. Most frequently seems to be how much, where, and then the time taken to modify if it's not sound. And that's really the essence of the longer, never-ending examination. And I think what Tim was trying to get at was making sure that the risk of an inadequate plan being submitted is minimized, and looking for some sort of, he didn't use the phrase, but something along the lines of a validation requirement early on, sort of before you set off. That's a very interesting idea. Can I throw another interesting comparison, perhaps? One sees in the reforms really strict deadlines being imposed. That's what seems to be the theme that emerges. And that's really quite easy to draw an analogy with what happens in terms of DCOs. And so we had a similar complaint that getting infrastructure underway took forever and a day. And the answer to that was an act which imposed absolute deadlines. And one can see perhaps the same theme jumping across. Now, I wonder whether, rather than focusing on the quality of the evidence, just having a threat as to deadline is workable in this regime, where you're not concerned with development of one number motorway. You're concerned with fascinating interactions which there are in respect of social, economic, and environmental future over a period of decades for a whole district.
We've seen reference, of course, to the production of a plan within 30 months from start to finish, which by Jerry's statistics earlier on will take some step change. I think one of the challenges we face is actually getting councils to plan and actually get on with it. And I think, as I touched on earlier, there isn't, dare I say, any punitive action for councils failing to plan. And there's a number of examples of councils have now come forward and said, actually, we're not going to do a new local plan until we know what's going on in the planning white paper. So places like Winchester and Milton Keynes have basically put their plan making on hold. And I know the chief planner quite rightly has written to everyone and said, no, get on with it, guys. We need to deal with this now. And that's completely the right message. But they aren't moving forward. And there's big parts of the country that are going to be affected by that. And I talk a lot, as some of you will know, about the Oxford to Cambridge Arc. Their spatial framework is coming out at the end of next year. That will apparently have national policy status, so similar to the NPPF, we assume. If any of those 26 authorities they are at the moment in the Arc, or slightly less with the unitaries being formed, how do they produce a plan at the moment? Because they don't know what the sort of national framework they're working within. So you can see excuses, as it were, coming out for those authorities, quite justifiably so, that actually they need to know what they're having to comply with before they start putting pen to paper. So whether there's going to be a start date here when these reforms come in, say, right, from this date, you need to be all starting to do local plans and have a day zero across the planning world, could be quite fascinating. I'm not quite sure what that does for Jerry's team's workload, but it needs to happen in some areas.
I like the zero start date, because it's all very well talking about 30 months from start to finish. The lawyer in me immediately says, well, when does one start? What's the starting date? The local authority can say, well, I just haven't started. My 30 months haven't started ticking.
Yeah, so there's a lot in this, isn't there? There's a lot in planning reform.
Yeah.
So yeah, that the comparison with national infrastructure is an interesting one, because whatever you think about deadlines, they have worked, haven't they? These have been examined on time. As far as I'm aware, it's not my bag. You can see that as being a possibility for examination, fixed timescale, and at the end of it, if it's not being found sound, then it's timed out. The consequence of that is that you can't have evidence being re-prepared, consulted on. You can't have big changes being worked up, consulted on, because that's just not feasible in probably 9 months, which the white paper talked about. So yes, you can, but inevitably it will be a quite different looking system. Maybe that would be a good thing. We're all going to be really interested to see what the incentives are, aren't we, to get on and plan now, and also to get on and do a plan under the new system. So we'll see what MHCLG come up with. And yeah, our workload, well, of course, that's quite fascinating. So if you take literally the white paper timescales, then it looks quite frightening for us, but probably also quite frightening for the whole of the planning world, because Tim and David, you're going to have so much consultancy work, you'll be cloning yourselves, I think, to deal with it. So that will be interesting. But of course, we don't quite know what the scope of the system is actually going to look like at the moment.
Well, that last remark brought smiles to everybody's face.
Can I just go back to the point that you were making, Richard, and I think following on from what Tim said, that the real controversial stuff isn't so much the development management policies. And I think that's Jerry was saying as well. They're much of a muchness, and they're pretty easy to iron out. And I think there's much to be said for Tim's idea of development management policies being standardised. It should be possible to standardise what somebody needs to show in order to demonstrate that their proposal will work in terms of highways or traffic impact or drainage or whatever it may be. And it's the same with design. You have a local design code, whatever it may be. That the real time is taken up with the big issues. How much housing do you need? How much commercial floor space do you need? How much distribution floor space do you need? And where it should go. There's a part of me which thinks that, yes, we have to have this evidence base, and evidence base has become more and more complex. But there is a part of me which says, is it really necessary? Why don't we just face the fact that those decisions about where the housing should go, etc., are essentially political? They are political decisions. That's why we have plans which ultimately are made by local politicians. If it was a purely technocratic system, you wouldn't need any local political involvement. And this is one of the things I've been saying about the planning system for a long time. It can't make its mind up about what it is. There's no real thought given to the real fundamentals. And without that, you're always going to end up with a confused system. So as far as housing numbers are concerned, for example, we now seem to be moving to a technocratic system where you have a formula, the formula tells you what the numbers are. And presumably there's no reason why you couldn't do something similar for other types of development. A formula which tells you what the country needs and where it needs it in terms of distribution centres, commercial floor space, whatever it may be. So if that's going to become formulaic and purely evidence-based in terms of what the economy needs, what the country needs, thereafter, if you're going to have political input in terms of where the housing should go, why don't we just accept that that is political? Why don't we simply accept the fact that the evidence is always moved around in order to support a decision which has already been taken?
I think that's a really good point, because I think, that is the nub of the problem, isn't it? If it was a technocratic exercise that you guys went away and did a plan, it'd be quite hard work, but you'd come up with a plan that would be fantastic. But the area of earthquake is in the middle where it meets the politics, isn't it? The art of what's possible, what will get people elected, what is locally acceptable. Planning is quite an interesting area, isn't it? It's probably the area of public service which is most mature in terms of public engagement and consultation. But consultation means people make comments and they have to be considered and listened to. It's a key area. My wife once said to me when our council was asking, what should the housing requirement be for where we live? She said, why are they asking me that? How on earth would I have the faintest idea what it should be? It's a specialist area. That was an interesting take. But of course,
Yeah.
people do want to be involved in what happens in their area, don't they?
I think going back to Richard, you were saying earlier that you're very much in favour of, and I don't think anybody would disagree, that you're in favour of knowing what the environmental impact of a plan is going to be. So you make a decision, this is where the housing is going to go, this is where the distribution centres are going, this is where the commercial floor space is going to go, this is the choice that we've made. Now let's have a look at what the environmental impact of that is going to be. And that's fine, because if political decisions are going to be made, they should be informed decisions. Often what happens with the SA process, and this is why I've become so frustrated with SAs over the years, is that you can make them say just about anything you want them to say, and you end up looking at these charts with different colours, and you think, well, where is this getting me? What is this telling me, if anything? And you think, well, a huge amount of time, money, resources has gone into this, and actually it just tells me nothing. Tells me nothing at all.
So can I split those two things out? Because the reforms do, and even the Queen's speech has got the point, dealing with the way environmental assessment is undertaken in a way which is more efficient. Is the issue here that the way it's done just impenetrable and full of tables with different colours in it? Or is it something that needs to be downgraded and it just follows the politics?
Actually, Jerry is very sensible and saying nothing.
Well, I'll fill the gap. Because it seems to me that what's happened is that we've got a system which derives from some European law, which is not entirely consistent with the Queen's speech either, because the government wants to make the most of Brexit. So let's make our own law in respect of environmental assessment. And SA and SEA have a bad name because they have to be done repeatedly. It's an iterative process and produce huge volumes of material, which, like Satnam, I find to be very frustrating. But the essential principle behind it is one of looking at alternatives to find out what the environmental effects are of the different ways of carving it up. One of my concerns is that information might be much less accessible if reform is so harsh and unyielding in respect of SEA and SA, such that it's virtually eliminated from the process. That seems to me to be the danger, that there's an opportunity to make things more efficient, but there is a danger of ending up in a situation where you're not really informing yourself about the environmental effects at all.
I mean, I think this is probably where things have gone slightly wrong for SA and SEA, isn't it? It's become a process that's taken on its own life that it sometimes feels almost parallel to what's going on in the plan, whereas, of course, what it should really be about is a sensible analysis of what the key choices were that the plan faced and how it made them, and then apply planning judgment to that. But at times, from examining plans, they do feel like they've become a separate exercise and a process that's done because it has to be done rather than one that's done because it's useful. So, yeah, there is clearly a problem with them. Yeah, where it goes, of course, that's where I'm going to stop talking.
Absolutely. Well, we're going to wait and see what happens, aren't we, in respect of that one. Back to the examination. This is an idea that crossed my mind, and it crossed my mind at a point where I was wearing a trade union hat. Getting to the number of the issues in an examination might be something that could be done in different ways, and all sorts of examinations and inquiries benefit from what's called counsel to the inquiry or counsel to the examination. I wondered whether there's any scope for having, in the larger, more contentious inquiries, where there are big issues surrounding need or particular sites, whether it would help the examination to have an advocate instructed to actually examine some of the evidence. Because at the moment we have purely inquisitorial system. It used to be the exact opposite. I wonder if there's a halfway house where the inspector has an advocate who's there as part of the examination to probe some of the evidence. I wonder if that would cut through things. And I thought Satnam would be great at it.
Well, interestingly, we are appointing, you may have noticed, 2 inspectors to examinations more often now. Sometimes they sit together, sometimes they don't. That's been a sensible thing, I think, to do for all sorts of reasons. Having 2 people involved in examination rather than 1, given their scale, and it makes them a bit more flexible too. I suppose my own take is that the round table discussions, the approach led by the inspector, I think that works quite well, actually, I have to say. But I think lawyers do play quite an important role in it. And I suppose I would see it is quite often you see them acting as a really helpful critical friend, particularly to the local authority. You know, the kind of nudge. The inspector might have a point on this one. We might want to think about this, or we'll come back tomorrow on that one. And that stuff is really helpful because it's kind of like a slightly external view, isn't it? And I think, as we know, lawyers really good at summarising, getting to the heart of the argument, and we do see that in examinations. And as an inspector sat there, you really know when the parties have all got QCs. You know this is going to be a critical issue. So don't see the current system of hearings as being a fundamental problem for examinations. It's perhaps a bit of a problem now that we're starting to see more people actually wanting to exercise the right to be heard, to the extent that some sessions have to try and accommodate very large numbers of participants. I don't think that can't have been originally intended back in 2004. West of England, I think there were three repeat sessions, the same session to accommodate 60 people who had a right to be heard. So that is a bit of an issue, I think.
Yeah, West of England was fun, and they had the huge benefit of a huge room. North Essex was equally fun, rather oddly, really. We were based in a football stadium, but we seemed to be all in the broom cupboard associated with the football stadium rather than anywhere near the pitch. And so I think, David, we might have been more comfortable, mightn't we, if we were on the pitch. But yeah, you're absolutely right. There's enormous numbers participating, and that might take us off into a discussion about the benefits of the virtual examination, but let's not take that in as well. So we've touched on getting to the examination. Satnam's dragged us helpfully back into that. We've been through the rump. We've had a good look at what's causing this rump of cases to take longer, and we've had a look at some of the reforms and comparisons to things like infrastructure and DCOs. That's not bad going, really, for how long we've had at this. Are there any points I've missed?
No, I think we've covered quite a bit there.
Yeah.
If only somebody would listen to us, that would be nice.
It strikes me that what we haven't got here is a local authority contribution, and we haven't got any contribution from HCLG. So maybe we'll send them a link to the podcast, sort of a Reg 18 consultation, and they can come back with their comments perhaps in the next episode.
Well, actually, that's an interesting point. So I was kind of, as we were talking, I was kind of thinking, here are all of us kind of pontificating on the local plan process. And of course, the minor missing party in this, of course, the local authorities who actually prepare the things in the first place. And I was kind of thinking, actually, the people who've got the really tough job are the local authority officers, because they've got to kind of put this thing together in the first place. It's really complicated. They've got to broker it through their political system and pick up the political nuances. Then they've got to get it through examination and deal with, consider all the representations. So for those authorities who actually get through to the other side and adopt a plan, I think that's a massive credit to the officers who've been dealing with it, really. It is an enormous job. They should be seen as inspiring others, it can be done.
Well, maybe we'll have a word with those who prepared the Milton Keynes plan to see how they went about it, because that's a good example. And we'll see if we can stitch something in on a sort of right to reply episode, which is only fair. But I've really enjoyed going through that and found it immensely helpful. Fantastic.
Thank you, Richard.
Thank you very much. Thank you, Richard.
Not at all. That was the planning podcast from No5 Chambers, looking at the current system, emerging local plans at examination, and what might work in a reformed process. If you are listening in a local authority or in HCLG with a story to tell or a response to make, do get in touch. Until then, and until the next episode, Wales. Stay safe and goodbye.